prøver så svar.
Mr. Taku, you have, of course, still the floor, and while the chamber is mindful of the time allotted to the defense, we would appreciate it if you perhaps could finish 10 or 15 minutes earlier, also together with Ms. Lyons, but we are, of course, mindful of the time we allotted to you.
Thank you, Honor.
Simply just we will see. We will see. Please continue.
Thank you, Honor. Now we have to. And they apply to everyone. And also, Your Honor, I'm going to go to the question of also victim perpetrator, which I will talk about. The prosecutor has not presented a single witness or evidence to show someone who was in the cohesive environment with Coney in the sense of Ongwen and who disobeyed Mr. Coney and survived. It is not enough to float these concepts in the abstract. You must be able to bring them within the context of the case that you are hearing. I just wanted to make that clear before I go to what the prosecutor says about Ongwen, and I'll be able to respond because I'm trying to respond to some of the allegations the prosecutor said in her opening statement. This opportunity for me to respond with particular focus on the charges and on Mr. Ongwen. Your Honors, one of the reasons, you probably had the evidence about Ongwen, the alleged perpetrator, but the prosecutor has not presented to you the evidence about Ongwen, the victim. Why is it important? The prosecutor has created this duality, which we say does not exist. As it was already said, once a victim. And from the overwhelming evidence of most of the people themselves who came here to testify, prosecuting witnesses who were victims were conscripted, and they say, we're still suffering from the trauma, we're still victims. Their own evidence defeat the argument. But I agree that this duality, victim-perpetrator, you lay out the evidence consistently when the perpetrator. Where is your evidence on when the victim? Why is it important? This will lay it before you so you can look at the balance and to see whether the victim situation on when outweighs the prejudice, the trauma of the victimhood which the prosecutor admits he was so significant that Ongwen could not control his actions, could not control. We don't have that, and therefore we have only a one-sided story. theories of moral choice, victim perpetrator, is floated in the abstract. And they don't even tell us how the same institution, LRA, that the prosecutor described in detail, that Dr. Ongwen and others, traumatized all these people. How Ongwen can be a victim and perpetrator within that particular structure. Now, in order to explain, I said the prosecutor quoted the case of a gang leader, if you can remember, that one can be a good father, a good mother, and become a gang leader. But the answer is very simple, Your Honors. There's no alternative structure here. The alternative structure with that Ongwen, although you were in the LRA, but you went out and created your own unit in which you superintended, you controlled and everything, and you committed crimes. They are saying that he is a perpetrator of his crimes for which he is a victim within the institution that had enslaved him. Now, the mere fact of they're saying that other people were adopted and put the mere fact in being in that sort of being adopted and the trauma of being there in itself, they themselves have laid out that case very clearly for all other people. And all the other people came here as victims because of our time. Even if we were there 6 months, we have the trauma. We cannot, even those who have been conscripted into the UPDF, in other words, what did they do? The people, Connie released because of the pressure of Iron Fist, the intensity of Iron Fist. Connie devised 2 things. In order to lessen the pressure on him, and we have evidence to show people were present, he sent the back to Uganda to divert attention. And UPDF now followed them to Uganda. And you'll find that within that time, Connie devised certain rules. He said, look, the political objectives will change. We are no longer interested in going to conquer power or 10 commandments. Iron Fist is now survivor. I have to flee. And he was on the run to Juba in Central Africa, where grew about 20 people, and a number of people, and the rest. The evidence will show, Your Honor, he released many of the victims, the vulnerable people and the women, including his own wives and his own children, and said there should be a freeze on the adoption. Now, you ask, but why, if there was a freeze, why did they go to Lala, Teso? Why was the adoption? Connie ordered the adoption in Teso in order to also lessen the pressure on actual land. And the evidence will show from people with him that if you take it to Teso, far away from actual land, the UPDF will follow you there, and you will look at the evidence from the victims themselves of the Lola attack, what happened in that particular case. The guys were brought to Connie. Some of them were brought to Connie. Some of them were released, and some of them are there in Uganda. The prosecutor did not bring them, but some of them were there. And some of the Connie's wives were released, including some of the Article 56 wives and the children. They were released by Connie. And Your Honor will also have evidence that today the prosecutor is saying, many people themselves, they surrendered. But the evidence will show that most of these people were released or were captured in combat. Many of them, because the prosecutor has not been able to demonstrate from the witnesses they called here to say, I fled, this is what happened. There were quite a number of people who fled, who were just newly adopted, and they were sent to look for food. And some of them managed at the lower ranks, but among the commanders. Only a few have been able to testify, but one of them who testified said that when I was living, I knew that Ongwen would be dead. And the question, why did you say this? He said the way Joseph Kony was talking about him. That's why. So this question of victim perpetrator, Your Honors, is in the abstract. It's a theory they didn't call agreed. Even if they wanted to develop, they didn't even call even expert evidence to explain what it is, can it, put in that context of the LRA. So we're also in the court that the example of the gang leader does not just apply here. And Ongwen was never a gang leader. And as the lead counsel has said, in the structure, you see how the structure changed. This question about rapid promotion of honors itself is not correct even because the reports which we will tender, we will submit by the UPDF in March 2005 shows the command structure was, and Sian Lebongo was Brigade Commander number 2, but there were about more than 12 other commanders in control order. And since Connie emphasized assignment than the matter of rank, Connie and Connie alone, you heard the evidence how Connie was purported to be interpreting promotion from the spirit. He never asked Ongwen. Ongwen was not one of the people, he was not a spirit medium. Maybe he was a spirit medium, I mean. So, Your Honors, it is very, very, very clear that the evidence will show that the charges as laid against Ongwen are completely misconceived. These charges is about Joseph Kony, it's about ARA, and the prosecutor's opening statement. For purpose of time, I do not want to be over the court. You will read it, in which, when I'm developing what the prosecutor says about Ongwen, then you understand that the prosecutor was well aware about the situation Ongwen, that Ongwen ought not to be here. Your Honors, the prosecutor set out the outstanding distinctive characteristic of Dominic Ongwen as a commander within LRA. The prosecutor stated that Dominic Ongwen could be kind and was loved by everybody. In other words, the prosecutor said, people following this case against Ongwen may do so with mixed emotions. And the prosecutor continued, quote, as a child, he, Mr. Ongwen, must have undergone through the trauma of separation from his family, brutalization by his captors, and initiation into the violence of the ARA way of life. He has been presented as a victim rather than a perpetrator. The evidence of many child victims in this case, in other circumstances, may be the story of the accused himself. Ongwen was a good man who would play and joke with boys under his command and was loved by everyone. This, we agree, but we disagree with the gang leader analogy, because the prosecutor did not present an alternative structure, which when created and set rules, or when kidnapped or whatever crime were not allegedly committed, or his participation within an alternative structure, will see the very structure that she has described as being very, very brutal. The rules did not pity anyone. I do not know of any other one, anybody who will survive the rule. And the prosecutor not presented a single individual here before Your Honors. So say here was a victim, but because he participated, obeyed Connie, he survived. He stood here. Let that champion come here, and the world and ourselves will celebrate him. But we haven't seen any. Your Honor, now, Your Honors, the defense agreed with the prosecutor that the people following this case against Ongwen may do so with mixed emotions. Indeed, the prosecution on Ongwen poses a legal and moral dilemma. Rod Owak, an actually traditional leader and prosecution witness, whom the defense demonstrated was a double informant in this case. This is what he had to say, Your Honors. He went to see the deputy leader, Vincent Oti, transcript of 9/6/2017, page 16. And this is what he says about Ongwen. Quote, I said he, Dominic Ongwen, showed his bitterness to everyone who went there. We couldn't know what exactly he wanted, because he indicated that his education had been ruined. If you go to your child and your child speaks like that, wouldn't he be showing his bitterness to you? If you go to your child and your child says, Daddy, this and that has already happened to me, he indicated to us that his education had already been ruined. Your Honors, when Rock testified, referring to him as your child, presenting your child before this honorable court and before the world, and to the full glare of the religious and traditional leaders actually learn is because they know that Ongwen is still a child, as is in this court. Because when childhood was stolen, Ongwen still has to grow up to a man when he's a child. And that's why a noted prosecution witness was saying, your child. He said, daddy. That's Ongwen saying to daddy. He knows Ongwen is a child. And for all purposes and intents, and for this case, Ongwen is on trial as a child soldier. Ongwen is a child, and from all other evidence and every indication, and from the results that your honors will see about the test done on Ongwen and his traumatic situation and the trauma of the RA, and I told your honors very clearly here that from the informant that the government of Uganda is trying to seal, that even in defeat, purported defeat, Joseph Kony is still very, very present. The mere thought of Joseph Kony, the dream of Joseph Kony, terrorizes the victims of northern Uganda. They came here, you heard your story. Ongwen cannot be the other exception. Or the prosecutor has not demonstrated about what I may call the prosecution exclusionary theory, that Ongwen is the only one. Even in northern Uganda, where you heard about Cheng, people who were not there, they are affected by Cheng. Ongwen's parents were killed when he was adopted. The sister, one of them, was adopted by Joseph Kony and forced into his own matrimonial conjugal union, to use the word. And when, of course, with the case of Brigadier General Salim Saleh that you know about, and many other instances from the even prosecution's case, how could Ongwen have had moral choice? How could Ongwen be a double status, this duality? So I just want to bring to attention that new theories have been brought here. It would have been more interesting if they brought more evidence, including expert evidence, to speak about this moral choice and how it affected, and put in the context of the charges against Ongwen, each of them, at the motive of liability, or the duality of the perpetrator within the structure of the ARA they themselves have presented here. That has not been done. It is floating in the air. It's in the abstract. Maybe it's for academics and others to test, to see whether it works, but it's not in this. It doesn't belong to this court, which is a court of law and fact, and which is a court of justice to do justice to Mr. Ongwen. Mr. Ongwen is not a guinea pig, but with new concepts in law, in criminal law, will be tested, will be floated and applied to his case. No. Your honors have determined very, very serious cases, some of which have participated, and you look at the law, the Rome Statute, and the law as it is, and the facts in the case. And that is what all your honors to uphold the spirit of the Rome Statute in regard to Mr. Ongwen. Your honors, I will now move quickly to the question of Ongwen having the opportunity to escape. Now, your honors, I don't think I should belabor this because this council talk about it, and I've talked about it, and time is of the essence. My eminent colleague, I know her eloquence, and for 15 years, when she gets up, I know what she has, so I have to get some time for her. Now, your honors, there's something of extreme, something that really of concern to me in particular, and should concern everybody in the judicial process before this court and international law, about the participation of many UPDF officers in the investigation in this case. One of them, P78, in his own statement and in the report submitted by the prosecutor, which we will submit, they said he was an intermediary and he was a liaison. But he was an active counterintelligence officer of the UPDF, prosecuting the war. He had this dual mandate. The protocol of intermediaries were completely ignored and violated because even the prosecutor investigated him when witnesses alleged that he had used the security to extort money from them. The prosecutor investigated, fair to the prosecutor. They didn't just sit back. But what is even surprising here is that the disclosed evidence shows that while an intermediary and liaison, he is one who located got over 40 witnesses, as the prosecution investigation report will show. 40 of the prosecution witnesses, most of them within the witness pool of former UPD LRA who surrendered or were captured in combat. But they came here, honestly, you know, these are victims, child soldiers. You get them from one coercive environment. They were there, forced into combat for all their years, and you conscript them back into the UPDF to continue the trauma, to continue. Or others were released to the camps, including the women. And this in the camps were also, some of them were conscripted into ADUs, and the women were exploited by the UPDF officers because of the economic situation. Now, the victims' evidence that was laid out here stopped short of bringing the conditions of these people, how the UPDF exploited them, and the people, former child soldiers, why still victims? Because they came here and said they still suffer from trauma. Now, to ascertain this trauma, you must be able to ask, where is the trauma coming from? Is it, yes, it could be, and it must be because of the adoption into the LRA. But the continuation of people, prisoners of war, who are surrounding that, people are all the combat, who are so protected by international law, for you to conscript them now and send them to combat. And I say so, and I'll give you the reference, because the assassination of Rascal Lukuya, both Rascal Lukuya and Ongwen were under the warrants of the ICC. And this intermediary and liaison had a mandate as an intermediary to capture him or to provide information by which we could capture it. It was during the peace process, the negotiation for safe passage. And he himself says, Your Honors, and let me say before I give you the reference, in his own statement, he says he got information that Dominic Ongwen and Rascal Lukuya were moving to RV in Musieni. That was during the peace process. And he sent former RAs. These are people within the victim, the witness pool that the prosecutor brought to testify in this case. He sent them and UPDF to lay an ambush and kill them. And they lay an ambush. Ongwen missed it. Rascal Lukuya was killed. And the question is, why kill him when you were intermediary? When they killed him, they themselves gave a report. They found on him a telephone and a notebook. There were only 5 of them. He was not in combat. It was possible to arrest him and bring to ICC, or let him proceed to the safe passage in order to save the peace process. This killed him. I will give you the reference quickly, Honors, but let me make all the points. I give you the reference of what he himself said. Now, the problem arises. During the safe passage, the commander of the 4th Division came here to say, I gave Ongwen the opportunity to come, release the children, and Ongwen declined. But if you know that this officer, this counterintelligence officer, who deployed here to kill Ongwen and Rascal Lukuya, was working directly under the supervision of the 4th Division commander was asking Ongwen to come. You now know why Ongwen could not, when he knew that they had missed killing him and killed his superior commander. Rascal Lukuya was number 3 in the ARA at the time. He was number 3. The second point is that another witness, a civil administrator, senior administrator, who was a double informant, because he himself said that he supplied OT with equipment, including gumboots and other elements, things of military value. In one other instance, he put a bomb, explosive in the touch to kill OT. When OT got it, and when OT did not get it, one of the commanders took it, opened it, exploded, and killed him. OT was number 2 in the RAA. Could Dominic Ongwen, hearing people, the same people who wanted to kill his number 2 and fail, wanted to kill him himself and kill his number 3, would he have surrendered to them or cooperated with them? And again, and more important, when they were putting pressure on Wen, release the children, or you yourself, there was a journalist on the spot who called OT and said they're putting pressure on Wen to surrender. And OT said, give the phone to the 4th Division. He gave it to him. He talked to him, let Wen come. And he let Wen. The evidence will show, in particular from the Luala schoolgirls, one of the victims of OT, that when OT was going to attack Pajule, OT called a commander in the UPDF camp in Pajule and said, I'm coming. And he called a number of other people, politicians, journalists, senior military officers in the UPDF, who were all working. The council clearly says it. They purported to be fighting OT while prolonging the war because the war had become a cash cow, and also because the overflow of support and aid, assistance to the victims in the camp never reached the intended recipients. It never reached the intended recipients. And that is why you ask, where did it go to? Of course, we submit United Nations reports and report other studies conducted to show, and also including Ugandan Parliament, the Hansard. It was debated in Parliament that indeed the question of the extermination of actually the victimhood, they prolonged the war in order for benefit, and above all. And that's why Ongwen, in order to, it's a cover-up for Ongwen to be brought here. So no, at the end of the day, they can say, well, Ongwen was 70 counts, there's no need to look elsewhere. We're there with this. But the question of ask your honor is that, is the government of Uganda cooperating with this court in order to provide all the evidence that you will need in order to do justice? I mean, to do justice to all. The answer is no. We have requests for assistance filed by the Office of the Prosecutor itself, including one by Ms. Fernandez, who was the Chief of Staff for Mr. Ocampo. She wrote so many of those requests for assistance, asking for specific evidence related to this case. Yes, yes. Specific evidence relating to this case. A lot of it. And you know what? The government of Uganda stonewalled. Even by the Joint Intelligence Committee, that P-17 states that it was formed specifically by the National Intelligence Service, under the control of the head of state. It's a constitutional organ by the President of Uganda, to investigate the case against the LRA crimes and hand over to the Office of the Prosecutor. Even that material, what happened? We have P38 now in the middle. He himself said he was not a member, he was there temporarily. They get the material and try to subject it to some scrutiny, remove part of it, throughout, conceal most of it. But the prosecutor clearly said, I wanted the report. And when I cross-examined him, where are the reports? He said those reports were not for this case. They were for UPF war operations. But the evidence will show, and some of the evidence already on record, that that commission was formed, that evidence was for this case, not for anything else. He misled this court. He could not be, the chain of command and the chain of custody through him cannot be effective because his involvement was just to dilute, control the report which the prosecutor has been looking for, asking for consistently. The Joint Intelligence Service, he has been looking for them in order to ensure that they don't get to this court. But more important also, Your Honors, apart from that, is the case that the government of Uganda has asserted national security interest. Look at that. The national security interest of the government of Uganda. But Your Honor, I don't have any time. I have the jurisprudence from the European Court of Human Rights. Once they have disclosed to the prosecutor or to a third party outside, they cannot. And why this blanket national security interest at this point in time? Had they not formed a joint intelligence committee to investigate the cases to help the court? Did they not investigate? Do they not have the report, including about intercepts and all the information which Ms. Fernandez and others requested that should be sent here, and the originals? including the UPDF officers who were in Lokodi, and people were on the spot to make them available to the prosecutor and to this court. And of course, Your Honors, we also have, I requested, went to Uganda to contact Padi Akunde and Jonathan Ifuza that you talk about. The reply of the government of Uganda, Padi Akunda is a civil officer of the UPDF, and Jonathan Ifuza is a civil officer of UPDF. Not being members of the ARA, they know nothing about the command structure of ARA, they know nothing about the internal work of ARA, they have absolutely no information to provide you, so we're sorry, you cannot meet them. It is, submit that in evidence for Your Honors to see, and ask whether the government of Uganda is cooperating. Whether these individuals, Padi Akunda was the spokesman for the UPDF in Kulu during the charge period. Of course, Tini Fuza, as you know, was the coordinator of intelligence services, member of parliament for UPDF. He was a deputy minister. So you cannot understand. And of course, you had Lapolo, who was the district commissioner for Kidgum. He is the one that was a double informant, as we pointed out. We tried to kill. Yeah. 1 minute, Your Honors. And Padi Akunda participated in these peace talks. So now, for the government of Uganda, for the purpose of this case, whereas one of their agents is now intermediary for the prosecutor, bringing up to 40 witnesses to testify against Mr. Ongwen, now their own superior commanders who prosecuted the war were in the peace talks, and they were the highest level of command. They now tell us they know nothing about the command structure of ARA. They know nothing about this case. They don't know. So they don't know what to talk about. So don't attempt to approach them again. So, Your Honors, you make a determination in this case. What is national security interest, and when can it be accepted? It is an issue that is important because the government of Uganda has written again a blanket refusal to cooperate with us in this case. Or, in some instances, as the prosecutor will say, even with the office of the prosecutor, they stonewalled. So the intention is, are they trying in any way to sabotage this case? Are we looking in the direction in which it's becoming discomforting to them? And therefore, they thought that Mr. Ongwen will come here and immediately will be convicted. But that is not the case. Your Honor, let me move very quickly to two other areas before I hand over to my colleague. Now, we are bringing to you we submit it to evidence. The evidence by Mr. Coney himself. Mr. Coney explained exactly the reason for why they adopted young boys and girls. In the news publication of the ARM/A, Mr. Coney says that one of the weapons that the government UPDF had deployed to fight to exterminate is HIV/AIDS. They get soldiers or others who are fully blown to go, and that there was a genocide of the Acholis. And therefore, he said before the end of the war, he, Joseph Coney, believes that the Acholis will be dead. And therefore, and this is in their own publication, what Coney says, and also the evidence of one of the senior commanders, some of the senior commanders were with him from the inception when he made the rules, was that he declared that they should adopt young boys and girls. He will nurture them, and they will grow. And he, Joseph Coney, will be able to put them in conjugal unions. They have no say in it. Both the men and the women, they are just there for this experiment to procreate. It is not, it has nothing to do with Aryan race. And I say this because, although it's not a prosecution's case, but Professor Masisi talked about Aryan race, which is most unfortunate, Your Honors, that was not what Joseph Coney said, and that we brought the document where Joseph Coney's ideas are. So Your Honor will know that it's Joseph Coney saying it's not what some other person tries to invent out there. And before I hand over quickly to my dear friend, that is, they call it Uganda, an official bulletin, the Ugandan, an official bulletin of RMA volume 26. It will be in evidence, Your Honors. We'll submit in evidence, so there's no need to go into details for this. And also, with regard quickly to the, of course, I don't want to go back to the camps, but let me finish quickly by addressing one issue of extreme concern to Your Honors. Your Honors, I must say one thing about myself. I hate to talk about myself in trial proceedings. This case is about Mr. Ongwen. And Mr. Ongwen must take the central stage in this case. And Mr. Ongwen will take the central stage because you remember, the evidence will show the very first statement he made to the ICC when he was surrendered to the ICC. Mr. Ongwen said, I was adopted from the hands of the government of Uganda to Joseph Kony. I was there, was not myself. I had no control over myself. Joseph Kony controlled everything about me. Now, he says, I escaped. By the time he escaped, he had been reduced to a private. And this is to challenge the idea of rapid promotion, because it was not a private. But Mr. Ongwen now says, I did not know anything that I was doing. That was the only way I knew. Fighting, I didn't know. That statement will be submitted into evidence, Your Honor, for that. But permit me, Honors, to conclude quickly to say, and I really apologize to talk about myself as well, and I make this comment with a very heavy heart. I'm not used to doing that, but I must make it, Your Honors, because I'm a media practitioner, and I have investment in the sector. The press brings accountability and transparency in judicial proceedings. Freedom of the press is a fundamental right worth celebrating. We will therefore not blame news organs that have demonstrated interest in this case and the judicial proceeding in this court. However, we will blame counsel when they express views in the press that violate the fair trial rights of Mr. Ongwen and the fairness of the trial. Mr. Ongwen is presumed innocent. He's entitled to a free and fair trial guaranteed by the Rome Statute and International Protected Human Rights. On the 14th September 2018, just 4 days to the opening, this opening statement, an interview was published in International Justice Monitor, in which legal representative for victims, and not my distinguished friend, Ms. Masida, for whom I have the highest respect. She is not the one. To make things very clear, I have the highest respect for her. They made the following statements about Mr. Ongwen at the trial process. Quote, for many of them, many victims, it doesn't make sense that the trial drags on because in their view, Dominic Ongwen is guilty from the very first day. So this trial shouldn't even be happening. And end of quote, and he continues, and they themselves say, well, among us, there was a lot of people that escaped as soon as they wanted. And what is this show? What this show is that Dominic Ongwen wanted to go up in the ranks. The question about the rights and due process. Your Honors, you will remember that during the status conference, when I first appeared before you in this case, I brought up this issue. And I said that to ensure, I quote my word, I'm sure that this trial should not be made into immediate circus. And I take, and Your Honor, of taking that the obligation of counsel, especially when we are representing victims and accused persons before this court. These victims are vulnerable. Even if you get information from them, in the context of your professional obligations, it's not for you to propagate them, to impugn it. It is wrong, and it's wrong. And when I brought up your other set, I'm sure that my colleagues will join me. The chamber will, of course, do everything that this does not happen. Your Honors, the petition of guilt, just a few days before the opening statement, and before you start his case, is a matter of grave concern. However, Your Honors, I would like to say, Your Honors, that reassured with the statement you made, and up to now, you've kept, make sure these proceedings are dignified. You've made sure there have been no incident. Apart from this, I bring to your honors about discussing the guilt of somebody who's presumed innocent. That presumption of innocence is one of the pillars, one of the blessings of international justice. Because we know very well that Ongwen has to explain his case. Even those of us who are Christians, even when Adam and Eve committed the crimes. The Lord gave them opportunity to defend. Why have you done this? We humans must do like the Lord did. Why have we not done this? Not to say that he must be guilty. So, Your Honors, and I ask the question, guilty from the very first day in an international court by counsel participating in the proceedings? Your Honors, you have the opportunity in this case where the matters are raising to answer the question and to set the standards for our generation and generations unborn. That is what this case is about. Thank you for your attention.
Thank you, Mr. Taco, and I understand that now Ms. Lyons will also have some submissions.
The material comes to me, whatever this is. Okay. You can give it to me. Let's see. Your Honors, it's a privilege to follow my eminent colleagues, my eminent and eloquent colleagues. That's the advantage of being last, but the disadvantage is I've listened and I'm tired. So let me proceed. I will try to stick to 1 hour, if that's okay with the court.
That's fine.
And that's okay with Mr. Ongwen. All right, and if it isn't, I'll be glad to stop if Mr. Ongwen needs, if he needs a break, at all.
I think it will be okay.
Okay.
Please continue.
All right. What I'm going to talk about for the next hour is fair trial. I don't have the opportunity to do the explanations I would have done about different rights and different legal sections I'm referring to, but I would, not the people in the courtroom, but would refer the members in the audience who are not familiar with these ideas to take a look at the Rome Statute, Article 67, which delineates the rights of the accused. I'll be talking about that. Take a look at Article 30, which deals with mens rea, which is the mental element of the charges, and especially take a look at 31A and 31D. We are putting out D as duress as a complete defense, a defense as through a prism through which we look at the other allegations and defend them. 31A, mental disease or defect, is related to 31D, and I will talk about that. But I understand that it may be difficult for those of you who have not spent most of your time studying this or working with it to follow. So please bear with me. I want us to talk a little bit about, first, why fair trial is important. And Chief Taku alluded to one issue, which is it's important in terms of helping us find the truth and make the historical record. So that fair trial, in a sense, and fighting for the rights of fair trial, which includes notice of the charges to the client, as well as disclosure obligations, information from the OTP to us, etc., is really part of the struggle for the truth, the struggle for fairness and the truth. That's what this is about. Fair trial rights are also human rights. This is recognized in the Rome Statute under 21.3, and it's also obviously recognized in international human rights law, particularly in the Vienna Declaration from 1993, which said that all human rights are universal, indivisible, interdependent, and interrelated. My colleagues have talked a lot about Mr. Ongwen being a substitute or a surrogate for Mr. Coney. I'm not going to go into that now. But what I will say about this in opening is it's our position that the OTP should dismiss all of the charges, the allegations of crimes and modes of liability against Mr. Ongwen, who is a victim. On the 12th of February of this year, the OTP issued a statement on the International Day Against the Use of Child Soldiers. And the statement said, "It is my hope such efforts of the OTP send a clear message. Crimes against children in conflict, including forcing them to bear arms, to kill and get killed, are unacceptable. They are grave crimes for which there must be accountability. A crime against a child is an offense against all of humanity. It is an affront to our basic tenets of human decency. Only with collective and unified action can we truly make a difference." And it's our suggestion that the Office of the Prosecution can start implementing its intent now by dismissing the charges against Mr. Ongwen, who was a child soldier forced to kill or be killed by Joseph Kony. In 1990, Uganda signed and ratified the Convention on the Rights of the Child. This was while Mr. Ongwen was being indoctrinated and forced to carry out the orders of Joseph Kony. In 2002, Uganda acceded to or ratified the optional protocol to the convention prohibiting the use of child soldiers. We ask the question, what did Uganda do to protect, save, or rescue Mr. Ongwen from the hands of the LRA as a child soldier? Based on my knowledge, the answer is nothing. We believe that Mr. Ongwen is entitled to the protections under international law, and that these should be instituted now based on their application to the time period of the charged allegations. And in addition, as my colleagues have said quite eloquently, Uganda must be held accountable for its role and its responsibilities in both the crimes that have been alleged and the failure to protect Mr. Ongwen, consistent with the international documents and covenants it signed. Now, the first issue I want to deal with is the issue of the plea. It's our position that it was a fair trial violation to proceed in this case because the taking of the plea in December 2016 was illegal. Let me explain this. We're not contesting the right of the trial chamber to take a plea under Articles 64(8) or 65. That's not the issue. But we believe that a plea should be voluntary, knowing or informed, and thirdly, unequivocal. Now, these standards were developed in cases by courts dealing with objections to guilty pleas. And when I looked, honestly, I could find no standards for a not guilty plea, which was the plea of Mr. Ongwen. However, logically, it occurred to me that they should be the same. So that's our position, that a plea of not guilty, as well as one of guilty, should be voluntary, informed or knowing, and unequivocal. But based on reading the record, this does not appear to be the case. It's our view that the plea taken in December 2016 was hardly unequivocal. Even the trial chamber acknowledged that the conclusion of the exchange, which I'll read below, Mr. Ongwen did not give an unqualified affirmation that he understood the charges. Mr. Ongwen was asked by the presiding judge at the hearing whether he read and understood the document containing the charges. His response, "I understand the document. I understand the document containing the charges, but not the charges, because the charges I do understand as being brought against LRA, but not me, because I'm not the LRA. The LRA is Joseph Kony, who is the leader of the LRA." We understand this statement to be that Mr. Ongwen did not understand the charges against him. He understood a translation he was given, maybe, but he did not understand the charges as being against him, which is the essential piece of understanding you need before you take a plea. And he later confirms this. It was a quote that Chief Taku read, "In the name of God, I deny all the charges in respect to the war in northern Uganda." Now, Mr. Ongwen's words were, he's quite clear. He was clear he didn't understand why he was being charged. And we asked the question, it's been raised a number of times, why isn't the person accountable, Joseph Kony, in the dock on trial? But as we looked at this record many, many times and discussed it, we concluded there's simply no way that a chamber could be properly convinced that Mr. Ongwen was aware of all the charges and the modes of liability which were confirmed in the decision of the pretrial chamber against him. The first problem is that Mr. Ongwen did not receive a complete translation of the 104-page confirmation decision in Acholi until mid-December, 7 days after the plea proceeding, and approximately 630 days from the English version. Secondly, there was a separate opinion of Judge de Brichambeau, who agreed with the COC, the confirmation of charges decision, but he had a criticism of it. In any case, this was not translated until 623 days after the June 6th English version. The other problem is, or the other issue is, that obviously not having the document violated Mr. Ongwen's right as an Acholi speaker to be informed, according to Article 67, in the language he fully understands and speaks, Acholi, and it was late. The second problem we have, although it was consistent with previous rulings in this trial chamber, we are still critical that the presiding judge did not request the reading of the 8 modes of liability for the 70 charges. Modes of liability is important because it explains to the defendant the role he is alleged to have played in the various crimes. So logically, there was no way that Mr. Ongwen could be informed of the charges without knowing what his participation was alleged to be. It just doesn't make sense. And I think that minimally, we would have expected the trial chamber to at least make a more specific inquiry as to what he exactly understood and would have taken the time to read. Now, these are issues that we've litigated. The trial chamber has rendered its decisions. There are public decisions on this. But I'm raising it here because that plea, a plea, not guilty plea, was a basis on which we're in this room now. So that's why I'm raising it as a predicate issue at this point. I would add also that at least there was one substantive, in my view, but substantive modification in the confirmation of charges decision, which is listed in that decision in paragraph 158, which deals with the timing of the allegations. And whatever Mr. Ongwen read back in January at the confirmation of charges hearings, it wasn't the same document. At that point, there were no confirmed charges. So this is also a problem. So to sum up on this, basically our position is that Mr. Ongwen indicated to both the pretrial chamber in January and also in December that he did not understand the charges as being against him. That didn't change. I also note that the statement of his understanding from January at the COC hearing, which was relied upon by the court, was in the context of waiving the reading of the charges. What this means is I say, okay, there are 70 charges against me. I, Beth Lyons, waive the reading of the charges. You don't have to do it, okay? Now, that's very different than saying, do you, Beth Lyons, plead guilty to these 70 charges? So that's the difference. And based on these factors, we still ask how it could be understood that the plea was voluntary, knowing and informed, and unequivocal. To borrow an analogy from horse racing, we're basically saying that, out of the gate, so to speak, this trial has suffered from a fundamental fair trial violation that permeates the whole proceeding. That's our position. The other point I wanted to raise in conjunction with this is that the problem of the plea in December, and this was at the pre-trial hearing, is compounded by the fact that the trial chamber had noticed that there were some issues regarding Mr. Ongwen's mental health status, and that could affect his understanding and ability to enter a plea. On the day before, we made a filing, the day before this hearing, we made a filing under Rule 135 and asked the trial chamber to order a psychiatric or a psychological examination to ensure his fitness to stand trial. And in that pleading, the defense stated, we received a preliminary report from the experts stating that Mr. Ongwen does not understand the charges brought against him at the International Criminal Court. Nevertheless, given the problems of the plea and given this added issue of question about psychological status of which the court was apprised, it's our position that the taking of the plea should have been postponed until these issues were resolved. It's clear that the mental health problems could impact on any plea, and it's clear he didn't understand the charges as being against him. Now, this violation prejudiced the defense because here we are, and it's a continuing fair trial violation as to what Mr. Ongwen's understanding is of the charges against him. The next issue I want to talk about is in Article 67. It deals with the issue of the right to translation. One moment, please. I started. Okay. a right to translation. In Article 67(1)(f) keeps using the phrase that in Article 67 keeps repeating the phrase, an accused needs to understand the charges in a language which the accused fully understands and speaks. Now, the defense has litigated the translation issue in respect to a number of documents and pieces of evidence. And frankly, we've been losing the battle in this trial chamber. I mean, we've been on the losing end of this. But it's still our position that a defendant who is not provided with the notice of the charges and modes of liability cannot enjoy the right to a fair trial. And when he's deprived of this fundamental right, he can't assist and he can't instruct his counsel in the preparation of his defense. Full stop. Related to this is the issue of translation and scheduling. Now, those of us who've worked for a while in international courts understand that translation always just takes up a lot of time, right? And it's translation of documents, translations of, and the interpreters and translators work extremely hard to make sure everybody understands everything. But our concern is that the scheduling that takes place in this court take account of the issue of translation and the rights of Mr. Ongwen and make sure that the proceedings are scheduled in such a way that is fair. This is not about fast tracking. It's not about finishing by X date. It's about fairness. We have two small issues two brief issues rather, they're not small, two brief issues I want to raise as examples. One is that this trial chamber has fixed the directions for the end of the case, the closing briefs, and the statements. And we have been litigating this, and basically the decision gives us 2 weeks between filing closing briefs and giving our closing statements. Now, our problem is that there's no way in that very short period of time that anything can be translated for Mr. Ongwen. Now, in the trial chamber decision basically considers that the information is out there, that closing statements are not and closing briefs are not new evidence. They're non-evidentiary. Nevertheless, this is the last time that all of the parties in this case, the prosecution, the defense, and the victims, will be addressing the trial chamber. And it's important to look at these documents and analyze them to understand what are the key points that are going to be raised by each party, and each of us, respectively, has to figure this out with our teams. So our position is that the 2 weeks is insufficient for the translation, for the client to digest and discuss with counsel these issues, and to comprehensively review the long documents that will be coming. Prosecution has 200 pages. The victims have 120 pages to share between two teams. By my calculations, that's 320 pages to review in 2 weeks. For an under-resourced team with a client who fully understands and speaks Acholi and who is not available 24/7 to read and analyze legal documents, there are problems. And there is clearly these factors lead up to a recipe of violation of fair trial rights in respect to the scheduling translation paradigm. There's also one other issue that's related here I want to raise quickly. And we're litigating this issue. It concerns the sitting schedule, in other words, the days in which this court meets. Towards the last session, Wednesdays have been a, quote, day off for Mr. Ongwen to deal with other needs. And while the chamber may be open to this further down the line, right now, it has rejected the defense request that this policy be continued. And it's our position that it needs to be continued.
Ms. Lyons, I have
yes.
to shortly interrupt you now.
Okay.
These are matters that, especially the last one, that,
Yeah.
that have been resolved by way of decision of this chamber or the presiding judge, for example. And I think it's not appropriate to bring this up in an opening statement, in this environment of an opening statement. This is clearly the scheduling. We have been very accommodating to the defense, and we will be so in the future. And I really think you should refrain from attacking in such a general manner, and which the audience does not understand really, these kind of issues, because it's really absolutely not necessary, especially referring to the last issue. Just one phrase to that. We know about these needs, and we have accommodated them, and it simply doesn't matter if it is a Wednesday or a Monday or a Tuesday, Thursday or a Friday, which is free. And we have said this clearly, and we will follow this. So this is not an issue, I think, to discuss here during an opening. I would really be happy, so to speak, if you would be a little bit less argumentative in your wording here.
Your Honor, for the record, my intent was not to upset the court or to attack the court, but to raise these issues in the context of fair trial. I understand how I was heard, and I'm moving on. Okay? Thank you. I'm going to move on now to the issue of affirmative defenses. As my colleagues have said, there are two principles which are fundamental to fair trial: the presumption of innocence of the accused and proof beyond a reasonable doubt. And these are enforced in Articles 66 and 67 of the statute, as well as 67(1)J, which states that there is no reversal of the burden of proof or any onus of rebuttal on the defendant. And consistent with these tenets, as my colleagues have said, the accused or defendant has no burden to do anything. Now, we're obviously arguing and participating and presenting opening statements with leave of the court. However, the defense can sit here mute, because the judges will be making deliberations based on whether the proof presented for each of the elements of the crimes charge and the modes of liability meets the proof beyond a reasonable doubt standard. However, we've raised, as lead counsel mentioned, we're raising an affirmative defense. When accused raises an affirmative defense, the prosecution's burden to prove each and every element does not change, and the burden does not shift to the accused. The affirmative defense is new, and it's a separate issue. But for this trial chamber, the issue is this: who should bear the burden of proof in respect to an affirmative defense, and by what legal standard should it be proved? The statute provides no guidance on this issue, and nor do the ad hoc jurisprudence, because the ad hocs are basically not united and not uniform in their holdings. However, based on our research, we would conclude that this issue is unsettled for this court, and the honorable judges here have the opportunity to set the standard. We believe the standard should be applied for an affirmative defense should be in sync with Articles 66 and 67, and that we should not adopt a standard, or you should not adopt a standard which shifts the onus of the burden from the prosecution to the defense, or somehow minimizes or undercuts the principles of proof beyond a reasonable doubt. Now, appellate courts in some common law jurisdictions have affirmed the same beyond a reasonable doubt standard for the prosecution when an affirmative defense is raised by a defendant. For example, Canada, the UK, Hong Kong, and also Australia. And in the UK, I believe, the defendant has an evidentiary burden to raise duress, for example, but once it's raised, the prosecution has the onus to disprove it beyond a reasonable doubt. So that in terms of summing up our approach, we would suggest a two-step process. The initial evidentiary burden on the defense to raise an affirmative defense with some evidence, and a shift to the prosecution to disprove the affirmative defense with proof beyond a reasonable doubt. And we will be submitting later a brief on this issue, but I wanted simply to raise the issue now because it's an important legal issue in terms of our defenses. Now, I'm going to talk a little bit about the elements of the defense, affirmative defenses. Now, the defense has given notice of two affirmative defenses as lead counsel has discussed. 31A, that Mr. Ongwen suffers from a mental disease or defect that destroys his capacity to appreciate unlawfulness of conduct or capacity to control his conduct to conform with the requirements of law. And 31D, that the conduct was caused by duress resulting from a threat of imminent death or of continuing or imminent seriously bodily harm against Mr. Ongwen or another person, and that Mr. Ongwen acts necessarily and reasonably to avoid this threat, provided that he does not intend to cause a greater harm than the one sought to be avoided. Now, it's difficult to go through each of these elements, so that I will try to at least talk about some points about some of them here. And then, as I said, we will brief them in more detail for your honors. Now, first, there's obviously an interrelationship between 31A, mental disease or defect, and 31D. The elements of both address the capacity of the person raising the defense, whether due to mental disease or defect, or to duress, who's to control of his or her conduct. Now, the defenses are totally interrelated. They both talk about this common element of control, perhaps a little bit differently, but it's there. 31A talks about capacity of the person to control his or her conduct. 31A, the capacity of the person to control his or her conduct refers to control by the mental disease or defect. In 31D, there are a lot of specifics about the threat to the person may be made by other persons or constituted by other circumstances beyond that person's control. When we put these elements together, the questions before us are, who controlled the situation that led to the mental disease or defect? And who made threats or created circumstances which were beyond Mr. Ongwen's control? The answer to both these questions, in our view, is the same: Joseph Kony. Under 31A, can a person with mental disease and defect form the required criminal intent? Our answer is no. Can a person with mental disease and defect form an intent to impose a greater harm than the one avoided under duress? The answer is no. Our position is that Mr. Ongwen, acting under duress, could not form the intent required for the crimes alleged and could not intend to cause a greater harm than the one sought to be avoided. My colleagues have talked a lot about the control of Mr. Koning and what I would describe as the misuse of perversion of spiritualism by Joseph Kony in the LRA. This resulted in the mental control over the minds of the soldiers in the LRA by Joseph Kony. As my colleagues have said, Mr. Ongwen's mind was not his own. Now, under the duress issue, let me say a little bit more about the threat piece of it. The threats required under duress are threat of imminent death or continuing or imminent serious bodily harm. We submit that the threats against Mr. Ongwen were imminent and continuing. The threats also talked about are against another person or that person. And we recall the testimony of P205, who talked about the collective punishment for escapes, the fear that family, clan, villages would be punished. There would be collective punishment if a person escaped. So this is something that needs to be considered. I've already talked about the defendant could not form the intent because he had no control over his mind and actions. But in defining the threat under 31D, it said it can be made by other persons or constituted by other circumstances beyond that person's control. In the case of Mr. Ongwen, our position is both conditions are met. The threats were emanating from the orders of Joseph Kony and enforced in a coercive environment over which the defendant had no control. Duress is the fundamental defense in this case. Duress, as I said earlier, is a prism through which to assess the criminal allegations against Mr. Ongwen. To put it another way, distress is an umbrella under which the 70 criminal allegations and 8 modes of liability are situated. Now, the Rome Statute is clear. The drafters of the statute made the determination that duress is a defense and not merely mitigation. You know, the mitigation position has been, is a position that appears to us to be supported by the prosecution and victims. Nevertheless, if the language of the statute on duress is found to be unclear, Article 22(2) mandates an interpretation of strict construction in favor of the accused. The support for the idea that duress is a complete defense is found in the separate and dissenting opinions in Erdemovich, from ICTY case, the separate and dissenting opinions of presiding Judge Casasi and Judge Stephen. Now, in both of their decisions, they basically hold that under stringent conditions, duress is a complete defense in international law with regard to war crimes and crimes against humanity. I won't go through the stringent conditions, but let me say they are very close to, conceptually, they're very close to what exists as the conditions in 31D. Now, Judge Casasi also recognized that duress can be a defense even against the most heinous crimes, such as the killings of innocents. He said, where there is a high probability that the person under duress will not be able to save the lives of the victims, whatever he does, then duress may succeed as a defense. He stressed that the trial chamber should decide with all the facts before it. What this means in other language is that in a situation where the person that duress is applicable in a situation where the person did not pull the trigger when somebody else would. In other words, if not Dominic Ongwen, then it would be somebody else who was forced to carry out the criminal orders of J.K. We believe that the situation of Dominic Ongwen, based on this these legal holdings even stronger than Adamovich, because in the case of Adamovich, he volunteered to be a soldier. Mr. Ongwen did not volunteer to join the LRA. As P-379 testified, P-379 was a witness who was abducted by the LRA. Nobody willingly joins the LRA. Nobody willingly goes to the bush. I've not met anybody who's gone willingly all the time I was in the bush. I'm paraphrasing the last phrases, but you get the point. Now, I wanted to talk a little bit about resources and fair trial, basically the inequality of arms between the prosecution and the defense. I'm going to make very brief bullet points, as we say, and refer the trial chamber has read and studied, I know, but refer others here to document 1098. It's a public document on the website. It's the defense request for additional resources and observations on fair trial from December 2017. All right, 1 second, please. Now, first, it's clear from looking at a number of criteria that there is no level playing field in this case between the prosecution and the defense. To us, that's what equality of arms means. Equality of arms under the statute, equality of resources, equality of personnel, equality in terms of investigations, in terms of information, in terms of technology, etc. It doesn't exist. Now, in terms of investigations, the fact is the OTP had an 11-year head start on the defense and considerably more resources to use during this 11-year period. The details can be found in a report from the OTP on the website called Report on the Activities Performed During the First 3 Years, covering the 2003 to 2006 period, which is relevant particularly to the crimes charged in this case. More recently, at the Assembly of States parties at the Assembly of States parties at the 16th session, the OTP indicated that in a 1-year period between September 2016 and 2017, the OTP conducted 31 missions in 3 countries against Mr. Ongwen. In comparison, the defense investigations did not commence till March 2015, when counsel chosen by Mr. Ongwen accepted his position. Now let's talk about the issue of personnel. Personnel involves not just who's sitting in the courtroom. It involves what I refer to as invisible team members who are sitting in the offices and different divisions of the Office of the Prosecutor. Now, as of December, this is December 2017 to be accurate, we made a comparison of the visible members in the courtroom between the defense and the prosecution. And at that time, there were at least 13 persons at prosecution tables who basically who were counsel who could question witnesses. At that time, in comparison, just as I said, for comparison's sake, on this side, we had 4 persons, and now we have 5. But you can begin to look at these numbers, check the reports, to make the comparison of the inequities. Now, what about the invisible resources? The invisible resources are the specialized units which are institutionalized in the prosecution office, the Gender and Children's Unit, specialized advisors, the special gender advisor to the prosecutor. I think there are 2 people now. And there's a planning unit, a planning operations, there's a strategies unit, an operations support unit, and there's a unit to deal with witnesses. No such apparati exists on the defense side, either through the Office of the Public Counsel for the defense, and certainly not on the individual defense teams. Thirdly, the issue of outmoded technology. I'm informed by those on my team, not I, but others who know, that the ringtail, which is a system through which evidence is cataloged and analyzed on all the teams, that the version that we had, at least in December, was 2008, about 2008, and the prosecution was using a version from 2012 to 2015. In any case, what does this translate to? It means more people having to do, takes more people when you're under-resourced with old technology to do the same task. So all these problems merge. Now, what's the prejudice? So what? Who cares? It's prejudicial in a case with the 70 charges and 8 modes of liability just because every point has to be investigated, the evidence has to be analyzed. And that's the problem. Now, the defense also contends that a lot of our requests have been forwarded to, or suggested we forward them first to the registry, and then they're dealt with by the trial chamber if we can't find some kind of resolution. And our position is that these fair trial issues, and we've said this before, but these fair trial issues are judicial issues first. And it's the registry under the Articles in the Rome Statute that implements the decisions. That's why we've been coming here first for determinations to see if we can resolve these issues. And lastly, Mr. Ongwen is a recipient of legal aid. And I'm sure that no one consciously in this courtroom would say that a legal aid recipient should have his or her right to a fair trial circumscribed by the legal aid system. I've worked in legal aid systems for too long, and I know what happens. It doesn't make it right. But I firmly believe that an international court should set the best, highest standards for a legal aid system and what it should provide in terms of equality of resources, not follow the worst practices that I've seen in New York City and that colleagues have seen, no doubt, in many countries that have legal aid or public defender systems. Now, the last issue I want to deal with in this section is the issue of disclosure violations. I hesitate to make a generalization, but I will because of time, and then go through a few specifics. But we've had a problem consistently, and we've litigated, as certainly the judges are aware, the prosecution is aware, those who read public redacted versions of our motions are aware. We've litigated late disclosures, missing pieces of disclosure, and exculpatory violations. Now, to date, let me just give you a few statistics. To date, excuse me. Okay, to date, out of approximately 25,000 items of disclosure we've received from the OTP, and that includes Rule 77, material to the defense disclosure, and your category of incriminatory. Only 45 items have been identified as within the exculpatory category. Now, these items were disclosed in 10 packages, and if our arithmetic, or the calculator's arithmetic, is correct, these 45 items represent only 0.18% of disclosure. Now, the question or the quandary for us is, where did all the exculpatory disclosure go? Now, I have to say, empirically, the percentages run counter to other international cases of either I've litigated, my colleagues have litigated, or I've been informed about. But I don't want to speculate, all right? I didn't do a whole data chart of this. The defense can't clarify or answer these queries, but we raise them because it raises the question of, is there more? And we also raise it as a question to the trial chamber because under 68.2, as the chamber and everyone else here is aware, there is a mandate to disclose exculpatory material as soon as possible, which has been the ruling of this chamber. As soon as practicable, rather. Now, in terms of late disclosure, we had a recent, here's a recent example. There was a meeting note disclosed about, there was a witness number P27. There was a meeting note from 2005 that was just disclosed in August, early August this year, 13 years after it was taken. Now, I don't know where it was. Maybe it was hiding, it got lost. I mean, who knows? But the point is that it's late disclosure, and in this case, it's late, but it also is prejudicial because the contents of the information was clearly relevant and material to the defense of duress. Had we had, the second point is, this was a witness who we interviewed a year ago, and the OTP was present in the interview, and they have notice of the interview. Had we had the note at the time a year ago, we would have been able to ask questions dealing, for example, with LRA function, its infrastructure, how Joseph Kony maintained control, details of his internal spy network, a number of elements that are, as I said, material to the defense of duress. Not having that note deprived us of that opportunity, and it was prejudicial. Also, I just want to call the court's attention to the fact that there is an appeals chamber ruling in the Caramera case in ICTR that says that exculpatory material cannot be buried by the OTP in general disclosure obligations. That's now, here it was disclosed as exculpatory. But generally, we're not supposed to have to look through 19,000, 20,000 documents to pick out what's what. It has to be marked as exculpatory. And if it isn't, this is a violation of fair trial. There are other recent examples of investigative meetings from 2004 and 2005, late disclosures. This is a problem. It's not a problem, it's a fair trial violation. And it prejudices our preparation and Mr. Ongwen's rights. So again, and thirdly, I would say, I'm sorry, not thirdly, but in addition, it raises for us the question, these numbers of the 25,000 versus the 45, of whether in fact the OTP is carrying out, is implementing its obligation under Article 54A that Chief Taku talked about, of its duty to investigate equally exonerating and incriminatory evidence. We've had a similar type problem with the requests for assistance, the cover letters that the OTP sends to the Uganda government for information. And the situation here has been that although the OTP let us know that they had found everything, they've disclosed everything, this was in September 2016, a year later, we're reviewing all the materials, and we found that there was a failure to disclose several of these requests for information, requests for assistance that were related to responses from the Ugandan government that led to the collection of evidence against Mr. Ongwen. These cover letters are not just, dear so-and-so, we want something. They contain information, and the responses to them important because they contain information. And basically, there are a number of examples which we have raised in our pleadings to illustrate what we are missing, what we don't have, and how it prejudices our preparation. Now, I believe I have 25 more minutes. Okay.
Make it even a little bit
Yeah.
quicker, we would appreciate it.
Yes,
but-
yes.
but,
I know. I understand. This is okay. The last issue I want to deal with is actually the first element of Article 67. It's the right to notice. And I would have dealt with in the beginning, but as you'll hear, it's a somewhat complicated issue, and I wanted to kind of save it till the end. As has been said, Mr. Ongwen, faces the most criminal charges and modes of liability prosecuted against a single accused defendant in any criminal case here, and most likely in any international court and tribunal. The trial chamber recognized this at a status conference in May 2016 and acknowledged this was a considerable case and said, the presiding judge said, nobody in this courtroom needs to be overwhelmed or intimidated by its scope. In any case, the chamber is not. I think I correct, chamber is not, okay. The defense is neither overwhelmed nor intimidated, but we want to emphasize that the right to notice, the right to be promptly informed of the charges against you in a language you fully speak and understand is even more important because its violation is exponentially increased because of the numbers. We're not dealing with one charge, one mode of liability. 70 charges, 8 modes of liability. Now, this proceeding is not the buffet approach to criminal proceedings. Notice isn't like a smorgasbord of charges and modes of liability. As lead counsel said, prosecution is expected to know its case before proceeding to trial, and it cannot mold the case against the accused in the course of the trial depending on how the evidence unfolds. Now, if I were back at legal aid a few decades ago, defense counsel would argue that the OTP on the other side of the aisle have overcharged this case. But it's not just a question of overcharging by an overzealous prosecution's office. As we've said, the prosecution's office is using this case as a showcase for the prosecution of LRA crimes. The only problem is, as we said, not only Joseph Kony isn't here, Mr. Ongwen is the person in the dock. He's an individual here. And Mr. Kony is not being held accountable. We have no problem with investigating all the crimes committed during the war in northern Uganda on both sides. But as lead counsel eloquently said, we have a problem with one-sided justice. It's called victor's justice, selective prosecution, selective investigation. That's our problem. And for the legitimacy of this institution, it's our position that both sides have to be investigated, and if sufficiency of the evidence is found, then prosecuted. Now, I'm going to skip over, I assume everybody here knows about what knows the jurisprudence on fair trial, etc. Some people better than I. Okay, I'm skipping all of that. But one piece I want to say is that there is a requirement, and this is important because we need to understand this when we look at where notice is lacking. There is a requirement that an indictment, I'm using that term, I come from common law, but an indictment or a okay, well, that argument afterwards. Or an indictment or a confirmation of charges decision, as an indictment is used here, must plead the prosecution's case with sufficient detail for there to be notice. Now, if it doesn't, there's a material defect. The legal standard is an indictment is defective if it fails to plead required material facts. So what are the material facts? No mystery. Judge Dolink in Natagarora said it's the who. Who is the alleged victim? The where, the when, the what was committed or omitted. Whom, to whom, the victim. By what means, the why, the motive. Answers to these 7 questions are necessary in order to individualize the accused, the alleged crime, the mode of the accused's participation, and the form of his criminal responsibility. And by charges, we mean both the crimes and modes of liability. Now, unfortunately, the notice in this case, we believe, is defective. I will not be able to go through all of my arguments about this, and we'll raise this in writing, but let me just briefly explain some of the ideas. Where do we look for notice? First, we look at the confirmation of charges decision. As trial chamber 7 held in its decision in the last case I litigated here, the Article 70 case, the COC, the confirmation of charges decision, constitutes the authoritative document informing the accused of the charges as confirmed, and the trial chamber is bound by them. Other documents is a pre-confirmation brief, and there's a pre-trial brief. These are auxiliary documents. And sometimes they can fill in the gaps, but they don't substitute for the confirmation of charges decision. Now, it's our position that, and we agree with Judge Brichambeau on this, that the reasoning of the confirmation of charges decision and the charges, there have to be some kind of connection to make a well-reasoned opinion. And this is important because he agreed with, but he also criticized in a separate opinion the decision from the pretrial chamber saying it does not provide the defense with details of what evidence was relied on and how the chamber defined the crimes. Now, Judge Brichambeau makes a number of other points regarding the lack of contextual elements, minimal, small amounts of evidence for modes of liability, no explanations by the judges for their decisions, no explanation of the underlying crimes and their elements, etc. And I urge you to look at his separate opinion because he can explain it better than I can, obviously. But it's an important overview as a starting place for this. Now, the issues of modes of liability, which Chief talked about a little bit, this is basically a legal quagmire. I'm not going to be able to do it in the next 10 minutes, obviously. It really is. But I want to talk about one mode of liability and its defects and then highlight the other 2. I want to talk about the defective pleading of command responsibility because essentially there are 3 elements, and I'm going to paraphrase. There's effective command and control, there's knowledge, there's power to prevent or repress. In other tribunals, it's prevent or punish. And essentially, these elements are repeated in the confirmation of charges decision, but in that decision, the elements for the mens rea, the knowledge, and the elements of power to prevent and repress are missing. It's missing the elements. You have to look at the document and say, are the elements there? And then look, are there material, factual allegations to support them? It's difficult to find factual allegations when the elements aren't defined. Basically, the paragraphs which purport to support these elements of command responsibility essentially track the statutory language. And it's been clear that this tracking of the statutory language has been found to violate fair trial standards. This was a holding in the Bemba appeals judgment in respect to the element of prevent and repress, and it's also a holding from the ICTR cases where the trial chamber said that an indictment was defective because it failed to plead any specific conduct to support knowledge and failure to prevent or punish for command responsibility or superior responsibility. And in full disclosure, that was a case that Chief and I litigated in military too, and didn't win until the appeals level, but that was a holding of the appeals level on that. The prejudice of this era is that it doesn't provide detailed notice. It also leads to a notion of strict liability, which has been criticized by the Bemba appeals chamber. They said specifically they held Article 28 here, command responsibility, is not a form of strict liability. This means that you have to plead every element. I'm not even dealing with the proof issues. We're not at that stage yet. We're dealing with defective pleading. That's a fair trial violation. So that it's not even pleaded. Each of these have to be pleaded, not presumed. And just because someone may be a military commander, a military superior, it is against the rule of law, it's against the holdings in law here to argue that the elements of strict liability are there. Now, common purpose liability is the next one. Essentially, the problem we have with this is that the notion of contribution is listed under common purpose liability, Article 25, individual criminal liability, but that there is no level of contribution identified. The pretrial chamber says it doesn't have to be significant. We say that means that anything goes, any kind of contribution made by someone involved in some kind of joint perpetration or joint liability would be okay. That's against criminal law. That isn't okay from our position. Now, I raise this here, and I'm not going to all the references, but I want to say that this court will have to decide, I believe, kind of the parameters of common purpose liability, because I don't think it's been decided at the appellate level here. And for those of us who've argued against and litigated joint criminal enterprise, we certainly take a strong position against this limitless kind of mode of liability without legal parameters. And as I said, I will continue those arguments in other forms later. In terms of the issue of mens rea and 25(3)A, I only want to say that there is an element. The problem in the COC, as well as the auxiliary documents, the prosecution, is the elements aren't always listed, and sometimes they're missing. And I will be able to support that in a different setting. I don't have the time now to go into that. But I want to say one thing. In terms of indirect perpetration, the element of the perpetrator's ability to frustrate the commission of the crime, which has been held to be an element of mens rea in Katanga and in Lubanga, both acknowledged by the pretrial chamber, is missing. It's missing that element. It's missing in the documents, it's missing in the COC, and that's an important element that has to be considered in terms of mens rea. The fact that it's missing means that the pleading is facially deficient. Similarly, in terms of persecution, there are issues as to whether, in our position, doesn't happen, but whether the allegations are sufficient to link a individual persecutory intent to Mr. Ongwen, who's charged here, as opposed to the positions of the pretrial chamber and the prosecution, which talk about in various documents, some more, some less, the animus, the persecutory animus of the LRA. based on our understanding, that 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 we can't find a criminal. That you can't criminalize under international law Mr. Ongwen's participation in organizations. That is not a sole basis on which to allege the animus for the crime, for the criminal allegations. Similarly, on the issue of conscription of child soldiers, take a look at the issue of common purpose liability. It's not pleaded. Take a look particularly, I think it was paragraph 663 on that, but I will check it for you. But the problem is that this is a problem of the charges in accounts 69 and 70 in terms of modes of liability. Now, the last point I'm going to make has to do with the issue of the sexual and gender-based crimes. And I will say that I know that my colleague, Abigail Bridgman, eloquently argued the jurisdictional defect in the crime of forced marriage, one of the crimes of which Mr. Ongwen is accused, in the hearings on the confirmation of charges decision. I'm not going to go into those arguments here. You can read them. They're from January 2016. However, I want to say that, one, that forced marriage is not a crime in the statute. Therefore, the issue for us is Article 22.2 applies. And secondly, it's only the ASP, in our view, which has the Assembly of States Parties, which has the power or authority or legitimacy to amend the statute to introduce new crimes. And there is no jurisprudence, in our view, that supports that the trial chamber or pretrial chamber has an inherent jurisdiction in terms of this. Now, the last issue is I want to talk a little bit about the sexual and gender-based crimes from the position of who's forced and by whom. And I'll do this very briefly and I'll end. We heard the evidence from the women who testified in the Article 56 hearings, the prosecution witnesses against Mr. Ongwen. The issue for us is, how should the evidence be characterized? If we characterize the conduct as crimes, then who is responsible? Is it Mr. Ongwen, who is carrying out orders from JK, or is it, from Joseph Kony, or is it Joseph Kony, the ultimate maker of, enforcer of the rules? In order to do this, the evidence has to be assessed objectively and dispassionately. And we trust that as professional judges, you do this. We understand that. But I raise it here because the defense is also aware that the sexual and gender-based crimes are highly emotional, or in the media parlance, a hot-button item. So before we even approach these crimes to analyze them in a legal form, such as a court, we have to look at what are the obstacles that may obstruct or prevent an objective analysis of the evidence and the elements by all of us. What makes it so difficult to look at sexual and gender-based crimes dispassionately and objectively? Why is there, I'm not going to speak for everybody, but I think there's a sense of unease when they're on the table. These acts involved in these crimes are intimate and tied up with a lot of emotion and feeling. And there's a gnawing reality that criminal acts described are often commonplace within relationships between people throughout the world, although most do not find their way into a court of law. We trust that the judges will extricate the emotion and look at the allegations dispassionately, but we want to raise this general point of perspective because we think it's important, and it's an important reminder to all of us in this room. We also want the judges to look at the charges and evidence in context. For example, remember that Mr. Ongwen, who was abducted as a young child, received his sexual education in the bush from Joseph Kony, and this has an effect. My colleagues have also already talked about the fact that Mr. Ongwen couldn't form the intent, but we want to say that neither Mr. Ongwen nor the woman could say no to the orders of Joseph Kony in respect to sexual relations without the likelihood of death. We submitted an example of a witness, a senior LRA officer, who was told that if he did not take a wife, he was forced to take a wife, and he was a senior officer, he would be killed. This is an example. Look, obviously there was sexual activity in the LRA, but the underlying issue is, behind this allegation of forced marriage and the allegation of forced pregnancy, who was forced by whom? And the examples that we've read about, we've heard, we've talked to people about is both men and women were forced by Joseph Kony. They were forced by the rules. No abductee had any choice. So from this we conclude that both the men and women, boys and girls abducted by the LRA, they're all victims who suffered harm through these policies and orders of Joseph Kony. He was the singular person who had the power to take advantage and to control the coercive environment of the LRA. Now, we will later make the argument, but I will say for now that obviously based on the facial deficiencies of the defects, we will argue that the modes of liability and the criminal allegations should be dismissed. Under Natagaroa, fair trial issues related to an indictment, or in this case, confirmation of charges decisions, can be raised, even post-conviction, and we will raise them. I would like to end with a quote. 2 more minutes. I would like to end with a quote, which I have to admit, the quote is used by a colleague of mine, Professor Lennox Hines, a renowned criminal lawyer, human rights lawyer. He's used it in his conversations about his Rwanda cases, so I didn't find it myself. But I think it's apropos to the fair trial violations. More than half a century ago, on 21 November 1945, Justice Robert Jackson, Chief Counsel for the United States, in his opening statement before the International Military Tribunal at Nuremberg, acknowledged that Nuremberg was a victor's tribunal, and he warned, quote, "We must never forget that the record on which we judge these defendants today is a record on which history will judge us tomorrow. To pass these defendants a poisoned chalice is to put it to our own lips as well. We must summon such detachment and intellectual integrity to our task that this trial will commend itself to posterity as fulfilling humanity's aspirations to do justice." Thank you.
Thank you, Ms. Lyons. This concludes today's hearing. We will resume on Monday, 1st October, with defense's first witness.
All rise. We will